We're live on 3FM 92.7, also on TV3 Ghana on Facebook, DSTV channel 279, all across the world on 3news.com. We are live on a number of radio stations, I must acknowledge, across the country as well. Honorable Chinia, are we live on your radio station today too?
Yes, I'm sure. Because
ask them to confirm.
Once I'm here, I'm sure.
I see. Okay, that is what?
Sisala Radio.
Sisala Radio. Okay. Okay. Well, 2 days ago, something happened in court with respect to this, the purchase of ambulance case involving the minority leader, Dr. Kesela Tufor, who is also together with the third accused in this case, Richard Jakpa. In fact, it is a statement that Richard Jakpa made emphatically, which, based on the correspondence from our legal affairs reporter, Lord Edwasari, was not contested by the Attorney General in open court. And I want us to take a look at exactly what Richard Jakpa is quoted to have said during cross-examination in court. Let's take a look at the quote. The quote attributed to Richard Jakpa in court. The Attorney General has on several occasions engaged me at odd hours to help him make a case against A1 as the first accused, in this case, Dr. Kesela Tufor. And I have evidence for that. If he pushes me, I will open the Pandora's box. He goes on to say, I don't understand why the Attorney General will accuse me of defending Tufor, that's A1, the first accused, when I am here to defend myself. If he pushes me, I will open the Pandora's box. I have evidence to that and to all of this. This was the statement by Richard Jakpa in court. Afterwards, the Attorney General issued a statement signed by the Deputy Attorney General of Eboa, but my colleague Pakwesi Asare had a conversation with the spokesperson of the Attorney General, that's Wilberforce Mensah, Isaac Wilberforce Mensah. He says that, well, they have video evidence of Dr. Kesela Tufor also coming to plead with the Attorney General to drop the case, and that they will release it if the need be. Take a look.
Willing at this time to release this tape for the whole Ghanaian public to know exactly what happened between the AG and the Attorney General? The AG and the minority leader.
If it becomes necessary, the Honorable Attorney General would. But as it stands now, I honestly do not see the necessity at this point in time. But believe you me, if it becomes necessary, the Honorable Attorney General will not hesitate to release the footage, which indeed is there.
So that's what the Attorney General spokesperson says. If it becomes necessary, this will be released. Let me welcome Sami Jemfi. He's the National Communications Officer of the NDC. He's a private legal practitioner as well. He was in court when all of this happened. Good morning to you. Jeff, welcome.
Good morning, Alfred.
And like Martin Bebo, I mean, I haven't read and seen the account of what happened in court. Can all of this and this particular statement and the reaction by the Attorney General that, look, me contacting this person at odd hours is part of the plea bargaining process, because this third accused initiated the plea bargaining, and some letters have been released to that effect. Can that explanation suffice?
No, it doesn't. It doesn't, because, you see, at this, my understanding is that at the time those meetings were held, the plea bargaining negotiations had broken down. So It means that because each letter that is written for plea bargaining usually has a duration of 30 days, right? Honorable, can you give me the section? Yes, so that I would read it out.
Act 1079.
So, as you, okay, can
I'll
you
get
read
it for you. 1039. If you look at the 16C 5. 16C5. If you want to read it,
1079, 16.
Where a person.
Okay.
Okay, so it says where a plea agreement is not reached within 30 days of the commencement of the plea negotiations, the court may proceed with the trial, right? Yes. So the thing was for 30 days. For 30 days, it didn't work. The court is proceeding with the trial. And so you can't be heard saying that you were still fixing yourself within the plea bargaining, what do you call it, framework. Yes, I know in practice, we still do. The court may continue, people still do, continue to talk. But once there is trouble, you can't ultimately say that you are covered by the plea bargaining law. When it is clear that what the witness is talking about is that he had been pushed, he was being goaded to come and testify against Atuforsen. That's what Jakpa is saying. That is what Jakpa is saying. That is not plea bargaining. This is what we call subordination of a witness. Subordination. It's not the same as subordination. No. Subordination. To suborn a witness. That's to induce a witness, sometimes through money or other considerations, for the witness to come and give false testimony, to come and perjure himself. So that's subordination. Jakpa can tell the difference between just bargaining with him, ordinary plea bargaining, and suborning him. It's very clear. That's why I'm saying that. So let's hurry up. They should bring out the tapes quickly so that we settle this once and for all. You see, because to be fair to the other side, you see that the Attorney General is also down saying that no, it was just ordinary plea bargaining, right? Yes. So to settle it is the tapes. And I understand the NDC will be holding a press conference next week, right? To bring out the tapes. So that when they bring out the tapes, then this matter will be settled. Because at a point, or right now, you will be fair to say that it's now become his word against the word of the Attorney General. Except that what still makes it bad is the fact that you can see that they are alleging that the meetings were odd, and involving certain government appointees in the Jubilee House. Hey, is that how ordinary plea bargaining is done? That people in the Jubilee House are people from the presidency, not just Jubilee House is big, yeah, but I mean specifically the president's lieutenants are involved in this meeting. So when the details are brought out, then you will see. So it's the nature of it that is tending to tilt a bit in the favor of Jakpa, and also the mention of a certain Supreme Court judge. So it's those facts on that government, one of the president's lieutenants is involved, a certain Supreme Court judge is involved, then you say, this is smelling. It's beginning to look, because ordinarily, that's not how plea bargaining is done. But as I said, this is what we call prima facie. So let's wait for the tapes. Then we will know where the chips will fall.
And talking about the tape, and Sami Jemfi, the Attorney General is saying, based on his statement, and even beyond what Wilberforce put out there, that he has come under enormous pressure from all manner of persons for him to discontinue the prosecution of Dr. Kesla Atuforsen, a minority leader. But he has not yielded, that he has video evidence of Kesla Atuforsen, Dr. Kesla Atuforsen, coming to meet him and to plead with him to discontinue the prosecution. And he has refused to do so.
Well, these are nothing but the words of a liar.
Why?
Nothing but sheer desperation of a sinking, or if you like, a drowning man. Drowning men always clutch onto straws. And that is what desperate Godfred Dame has been reduced to, trying to clutch onto straws. What he's saying is tantamount to a thief who is caught in KJTR, saying that, oh, don't crucify me because another thief stole at a doom. That is what he's saying. So you have been exposed for your professional misconduct, unethical behavior, and criminal conduct in court by an accused person testifying under oath. You could not object to that evidence in court. In open court, when that evidence was given, you could not object, you could not contest it. You could not even apply to the court for it to be struck out, which is what any lawyer who thinks he's innocent would do. Who thinks that a certain piece of evidence is vexatious, flimsy, frivolous, scandalous, would do. He could not do that. He was in court himself. And I'm going to, and I'm going to demonstrate that to you. You could not do that. Like a coward, you were shivering in your chair. Okay? Totally silent, couldn't utter a word. Because he was clearly scared of what the ramifications was going to be if he dared the accused person, Mr. Richard Jakpa. Because he actually said, if you dare me, I will open the Pandora's box. And Godfrey Dame, the coward, was shivering in his seat, couldn't utter a word. Now, after the court proceedings ends, he now comes into the media to issue a press release to obfuscate the issues, making counter allegations. Why did he lose his mojo in court? Why couldn't he make those allegations in court? In any case, let's subject what he's saying to common sense. You are a prosecutor who claims to be fighting corruption. Somebody comes to you, according to your claim, to compromise you not to do your job that you're obliged to do under law. Is that person not engaging in the commission of a crime?
Mm-hmm. Yes.
So since that incident happened, what has he done about it? Has he even spoken about it before?
You only said he refused.
Why did he have to? If Martin Pebu is a prosecutor and you try to influence him to drop a case, you think that he will be quieter and wait for the day he is exposed in court before he will throw that in? So clearly this is a desperate man who is trying to clutch onto straws because he knows that his sins have found him out. His day of reckoning has come. His cup is full. He is drowning under the weight of his criminal conduct. And therefore, he needs to equalize, obfuscate issues. You see, let's get something clear here. The context of this discussion is very important. This is not an issue between the NDC and the MPP. The NDC has not made any allegation against Godfrey Dame as far as this Ato Forsen case is concerned. Even Ato Forsen, our minority leader, has not made any allegation against Godfrey Dame, the Attorney General. This is not about politicians trading accusations in the media. So when you see Godfrey Dame issue a statement, and in the first paragraph of the statement, trying to reduce this to allegations from NDC people, that is the word of a liar. He is trying to turn this issue into political football so that he can exculpate liability. Because he knows that in this country, once a matter becomes NDC MPP, the noise doesn't allow people to appreciate the truth. And that is the game plan he's playing. That is why he got his surrogates like Paul Adomotre to put out that circus on TV.
We don't know that.
Okay, I know that. You understand? What is the issue about if it is not an NDC MPP matter? This is a criminal trial involving the leader of the NDC caucus in Parliament. Government is prosecuting him for his role in the procurement of 200 ambulances for the state. As you may be aware, sometime in November 2012, the then NDC Mills government entered into an agreement with a company called Big C Trading LLC to supply 200 ambulances to the Ministry of Health and by extension Ghana. At the time, Honorable Ato Forsen was not even in government. He got appointed as deputy minister under NDC2, John Mahama, and served as deputy minister throughout that 4-year tenure. Now, in 2014, on the authority of his boss, the substantive Minister of Finance, he wrote a letter to the Bank of Ghana for letters of credit to be established in favor of Big C's to serve as payment security for the supply of the ambulances. Now, the Attorney General contends that he wrote that letter without authorization and that some loss has been occasioned, and for that matter, he is responsible. He has occasioned that loss. We dispute that because there is ample evidence to show that he wrote that letter on the authority of the finance minister and that there was nothing unlawful about the letter he wrote and that that letter has occasioned no financial loss. But because the matter is sub judice, I will not prejudice the matter. Let the court decide that. Now, Atuforsen has opened and closed his case. Okay? It is now the turn of the third accused person, who is a businessman, not an NDC member, a businessman called Richard Jakpa. He owns a company called Jakpa at Business Limited. And his company served as the Ghanaian agent of Big C. So Big C itself, which is a foreign company, is not being prosecuted. But the Ghanaian agent in the transaction, Jakpa at Business Limited, is being prosecuted. And they are the director or shareholder is the third accused. And it is now his time to do his case. Now, he was being cross-examined on the 23rd of May, 2024, by lawyers for Atuforsen, first accused. The lawyer who did the cross-examination was our own brother, Eduji Tamaklu. Now, in the course of the cross-examination, he was asked about the letter Atuforsen wrote to the Bank of Ghana for letters of credit to be issued. And what the lawyer sought to establish was that the letter was on the face of it, was with authorization of the finance minister because it had a seal of the finance minister, which seal can only be given to a letter sanctioned by the finance minister.
And not
that was the question. So I have in my hand here, I'm not going to make up anything because this is a serious platform, the certified true copy of the record of proceedings of the High Court Financial and Economic Crime Division held in Accra on the 23rd of May 2024 before Her Ladyship Justice Efia Sewa Asaribuchi, Mrs. J, sitting as an additional High Court judge. This is the true account, certified true copy of what happened in court. Now, if you check from page 24, okay, just to know what happened. So the lawyer, page 24, asked, have a look at Exhibit B2, and I've sent you a soft copy of the record of proceedings. Have a look at Exhibit B2. Can you see a seal on Exhibit B2? This is the letter Atuforsen wrote to the Bank of Ghana. Then the witness, the third accused, Jakpa, answers, yes, my lady, I can see a security seal. Then the lawyer asks him again, can you tell the court what seal it is, if there is any name, agency, or department of Ghana on it? Then he says, it is the Controller and Accountant General's Department security seal. Then the lawyer says, you will agree with me that without this seal from the Controller and Accountant General's Department, the Bank of Ghana will not honor the payment. Then the witness says, yes, my lady. And to explain further, there's a seal that is in the office of the finance minister. Any letter that originates from the office of the Minister of Finance, if it is going to the Controller and Accountant General, carries the seal of authorization from the Ministry of Finance office. And it goes on and on and on. Then Godfrey Dame, I want you to know that he was in court. You see his name there, Honorable Dame.
Yes.
He rises to raise an objection. My lady, I am a little bit constrained to intervene because the Minister of Finance at that time was in court and testified about authorization. I wonder what Mr. Jakpa's business is to testify about authorization. So the court intervenes to correct the witness, okay? Then Dame comes in and says, just by force to defend other accused persons. So he was throwing a shot at Jakpa, but Jakpa was trying to defend other accused persons. So the court intervenes and says, no, that is not the point. Honorable Attorney General, do not talk. 2 days ago, you caused a third war here, so please. Then Gordon Tamaklu, lawyer for Atuforsen, intervenes. My lady, I do not know what the problem of the Attorney General is against A1 Atuforsen. Then by court, you people, please. Then Mr. Tamaklu, where from this defense? Is he defending him? Are we not entitled to cross-examination? No, what is this? Then the court intervenes. Mr. Tamakula, I do not have a gavel. Please, all of you just resume your seats. Then Honorable Dame comes in. Attorney General. Why am I even calling him Honorable Dame? This Honorable Dame comes in.
Well,
my lady, the point I'm making is actually part of my objection. If my learned friend wants it to go on record, then let it be on record. Then Godwin Tamakulu, lawyer for Atufosin, comes in. My lady, if he thinks the question is not properly asked, the question can be disallowed. Then the court comes in. So this goes on and on and on. Then Mr. Jakpa flares up and drops a bombshell. Okay? He says, my lady, I want to put on record that I am not here to defend A1, which is Atufosin.
This is on page 8, eh?
Page 28.
28.
Okay? Then Mr. Jakpa continues, my lady, I have heard that, but I want to make it clear here that the Attorney General has on several occasions had meetings with me privately at odd hours, both in person and on phone, in respect of this case, to cooperate or answer questions in a manner that will make his case better against A1. And I have refused, and I have evidence to that. And so if he is accusing me here that I am here to defend A1, he has brought hostilities to my doorstep, and I am responding to the hostilities. And if he continues on this angle, I will open the Pandora box, and we will all know actually what transpired. He has brought it up, and I will give it to him. Then the court told him to sit down. And Mr. Japa continued, I am angry because how can he accuse me to be defending A1 when I'm here to fight for my liberty? And he has been impressing on me to cooperate with him so that he can put A1 is Atufosin, in jail. And I refuse. So he comes here to accuse me of defending A1. It is unacceptable. Then the court cautions him again. Then Mr. Japa says, so if he dares me, I will open the Pandora's box here. And I have evidence for that. He continues to say, let us slag out, and I am ready for that. The court had to contain him. Look, in all this, the court retired to chambers, came back, and all that.
And rules.
Yes. Right in now. All this, Godfred Dame could not utter a word. In fact, if you go on and on, you will see that the judge actually said, let whatever Mr. Jack Patel accuser said be captured on record. And that is why it is in the record of proceedings. So this is not an allegation from the NDC. And we in the NDC are saying that we are totally scandalized by this. We are disgusted and appalled by this revelation. Because this is not about a mere lawyer. This is about a man who is supposed to be an attorney general, a minister of justice. The man who is supposed to be the leader of our bar. And therefore must be an ardent follower of the ethics of the legal profession. Behaving like a crooked character, criminally minded character who has no respect for the right of accused persons, no principles, no morals, no integrity, no honor. And we are saying that we want the world to know what happened in court. And even beyond what happened in court, we have very useful evidence that will convince the whole world about how evil this Attorney General and the government he represents are, and the desperate lengths they go to pervert the course of justice just to victimize political opponents for cheap political goal scoring. Look, there are two lawyers here, one law student here. Our work is governed by ethics. If you check the legal profession, professional conduct and etiquette rules, LI 2324, okay? Rule 14. I want to read to you Rule 14. This is what it says. Rule 14. It says that, Rule 13, sorry, communication with represented party. A lawyer shall not approach, communicate, or deal with a represented person on a matter or attempt to negotiate or compromise a matter directly with a represented person, except through or with the consent of the lawyer of that represented person. So, Jakpa is a represented person. His lawyer is Tadiosori in this case. Godfred Dame, who is supposed to be the leader of the bar, knows of this rule. So why will you be engaging him without his lawyer to compromise him, to get him to skew his testimony in a certain way that implicates an innocent man. This is not the only rule of ethics he has breached. Check Rule 40, which is a special responsibility imposed on prosecutors, not lawyers, prosecutors. Special responsibilities of a prosecutor, that's the title. 41, where a lawyer acts as a prosecutor, the lawyer shall act resolutely and honorably within the limits of the law and shall treat the court or tribunal with candor, fairness, courtesy, and respect. Calling and meeting a represented accused person at odd hours, impressing on him, seeking to coerce him, to fabricate and falsify his testimony against an innocent man. How is that acting resolutely and honorably? But the most important one, Rule 54, integrity of evidence. This is what it says. A lawyer shall not advise or suggest to a witness to give false testimony. To give false testimony. This is the responsibility of lawyers. And so you see, this conduct by the, and I'm relying on it because this is uncontroverted evidence. Dame was there. He could have objected. He didn't object. He could have moved the court to strike it out.
Anything when
this is the record. It's not there
in court, and
because he knows he's guilty. That is it.
Aspect of
it. So once you did not defeat it, yes, you did not dispute it, it is as good as being admitted. You understand? And I'm saying that this is professional misconduct. This is unethical. This is a disgrace. Godfrey Dame is a walking disgrace of the legal profession.
In his statement, he said the Republic
and that hallowed office.
The Republic has never required or desired the cooperation of any of the accused persons in the matter, in which it has already succeeded in establishing.
Why didn't he say it in court? This is press release to Alfred Okansi and the media. Look, Jakpa was testifying under oath, meaning that whatever he's saying, if he lies, he goes to jail for perjury. Is Dame testifying under oath? Is he even speaking to a judge in court?
Well, this was a press statement after the...
Anybody can write anything in a press statement. It's gibberish. I'm saying that when your accuser was sitting in front of you in that box, why couldn't you say this? Why couldn't he deny? Because the accuser dared him that if you want, dare me. He's a coward. He's lying. And we are going to put out indisputable evidence which will let you know that this man is just a criminally minded, crooked character who is just lying. Yes. Look, he says that to obfuscate, even before I get there, let me demonstrate to you again that his conduct is not only unbecoming of a lawyer, not to talk of an attorney general, it is not only unprofessional and unethical, but also criminal. Because if you check the Criminal Offences Act of Ghana 1960, Act 29, Section 213 and 214, if a lawyer can help me, it talks about fabrication of evidence. Yeah. You can't bring any circumstance to exist which deceives a judge or a court about the existence of something which is not there. It is called fabrication of evidence. So if you are telling an accused person to come and bear false testimony against an innocent man, what you're seeking to do is that you want to fabricate evidence to deceive a court, and that is a criminal offense. And that is why I've been using the word criminally minded attorney general. I want you to know that I'm not here to attack anybody without sufficient grounds. And I want to put on record that Godfrey Dame will be the first attorney general who will not only be reported to the General Legal Counsel for professional misconduct, but will be prosecuted.
You're going to
prosecuted for fabrication of evidence, which is a crime. Mark my words, this is going to happen. Now let's go to his wishy-washy defense. They issue a statement number one. They say they have never met the gentleman. In one breath, they've never met him. In another breath, they say that, oh, this meeting the guy is talking about was part of plea bargaining. So did you meet him or you didn't meet him? Now, if you are talking about plea bargaining, let me demonstrate to you. And Paul Adomoche and his likes should be listening for free education.
If you look at
that plea bargaining does not even arise in this matter. It's a total red herring. Let me educate them. Look, plea bargaining has been introduced into our Criminal and Other Offences Act by Act 1079. It governs how plea bargaining is done. Section 162A3 says this: where the accused person is represented by counsel, the plea negotiations shall be between the prosecutor and counsel for the accused person. So the letter they are bandying about, what is being circulated, which is a letter from Big C to the Attorney General that you are prosecuting our agents. They didn't beg the Attorney General to forgive them. He said, you are prosecuting our agents. We are not a party to the action. We can't defend ourselves. But this matter can tarnish our hard-earned reputation. And therefore, we want to settle. You claim that the ambulances we supplied has occasioned you a financial loss. Ship the ambulances back to us. Let's pay you your financial loss of 2 million euros. Is this Mr. Jakpa begging Godfrey Dami to drop a case? It's a proposal for settlement. And the law allows for that.
Which
Then the Attorney General, listen, writes a letter dated 24th May. I'll give you this letter too. Dated 24th May 2023, last year. And says that we wish to inform you that the terms of your proposal are unacceptable. So he rejects the proposal. A revised proposal is sent. He rejects it again. So plea negotiations never began. Let me put it on record. There's not been any plea negotiations in this matter. A proposal for settlement was made by Big C's through Jakpa, third accused, who adopted the proposal. Right? The Attorney General says, I don't accept it. So the plea negotiations never happened. In fact, if the plea negotiations had even started, right, the judge would have just given them 30 days to reach an agreement and inform the court. After 30 days, it expires. So let's even assume, I have demonstrated to you that the Attorney General rejected it. So the negotiations was not even initiated. But assuming without admitting that there were even negotiations, it would have ended in 2024, maybe June, July. 2023. The calls and meetings we are talking about happened a few weeks ago. I'm giving you breaking news here.
The calls
and
hours.
The evidence will be putting out. I'm giving you a hint. It didn't happen any 1 month in any 1 month.
It happened a few weeks ago.
Yes. So where does plea bargain come here? And in any case, the letter from Big C's was signed by their lawyer. The letter from Jakpa, third accused, to the Attorney General, saying that this is the plea, this is our proposal for settlement, was signed by Richard Jakpa's lawyer. So assuming that the Attorney General wanted to engage them in plea bargain, won't he engage them through his lawyer? Which is what the plea bargain act says. And lawyer has read to you that they had 30 days. In fact, the judge has ruled in court. You remember that the judge issued a bench warrant for Richard Jakpa.
Yes.
You know why? Because when he wrote the proposal, he was under the impression that they were going to negotiate. So he was not going to court. At some point, the judge demanded his appearance in court and said, once the 30 days has lapsed, I am continuing the adjudication. So he's opened his case. He's under cross-examination. And whilst under cross-examination, you are having meetings with him under the cover of darkness to falsify his testimony. Answer, just a fixed match. Or team Kobobo. No, actually play and he say. He is coaching the accused person, answer it this way, so that you can incriminate an innocent man at forcing. He is the one I want to jail and I will set you free. This man is a crooked character. Listen, I want to conclude by telling you this.
Here's the section. I thought you want to read.
Yeah, yes. 213. 213. A person who fabricates 213 of the Criminal and Other Offences Act. Okay? A person who fabricates evidence with intent to defeat, obstruct, or pervert the course of justice in a proceeding commits a criminal offense and is liable to the same penalties as if that person had committed perjury in that proceeding. Now, 214 says, a person fabricates evidence if that person causes a circumstance to exist. That is what I'm interested in. Causes a circumstance to exist. Okay? And it goes on and on, with intent to mislead a public officer, judge, or juror acting in the judicial proceeding. So you are causing a circumstance to exist to deceive a judge when you go and tell a witness to give false evidence about an accused person. And that is why the man will not go scot-free. Look, I am saying it here so that my other colleagues can come in. that Honorable Atoforsen, you know I have a very good relationship with him, okay?
I know.
Honorable Atoforsen is daring Godfrey Adame to put out any evidence, video, audio, paper.
He says he has video evidence to that effect.
I'm Robert Yachin that. He will say anything to go scot-free.
So you are asking.
Show us the evidence where Atoforsen came to you and
Okay.
said, "My brother, I'm begging you, drop the case against me." Show it, because
Right.
you see, this one you should not even be issuing threats, because this is an attorney general who is supposed to be exposing suspected criminals that he is prosecuting, who are trying trying to influence him. Okay, he is supposed to be doing that. So if you have this evidence, this is good evidence. The fact that you will even be concealing that evidence shows he is very corrupt. He doesn't have. Even if that evidence existed, it will not show any wrongdoing on the part of Atoforsen. Get that clear. That you, a police officer, you come and arrest me and you put false charges on me, and I come to you and say your charges are trumped up. Stop it, drop it. It is not a crime. It is. He is not a lawyer. He is not. He's not under any responsibility not to communicate with a prosecutor. It will not even be a crime. But I am saying that it has never happened that Atoforsen has gone to Adame to beg him to drop any case. He is only saying this to obfuscate the issues, reduce the matter to NDC MPP football so that he can go scot-free. He can't go scot-free. He should meet Jakpa in court on Tuesday.
You said you are going
He should
to
meet
also
Jakpa in court. You know
him. Yeah, I know.
Have you heard that name?
Yes,
You should meet Jakpa. He has dared him.
You are going
meet
to
him in the box.
Report the Attorney General to the General Legal Council.
Oh, live and colored.
And you would have him also
Live and colored.
You're going to court on this matter.
Live and colored. Mark it down.
How much? I mean, you and I. Well, you are a student of law. Yes.
Well,
And so I will say that if, based on the records of the court, certified records, I'm sure you have a soft copy. Please check your phone. Check your phone. We've sent you all the documents that you have to.
so you know, I can't read it at this. I can't read it at this spot, but no
Yes,
problem.
Indeed.
I can be your
Well,
give me the quotation. I can read
the first point I want to make is that Sami, my brother, in his submission has made reference to Paul Adumochire about 3-4 times. And I think that it is not fair because he's not on this platform. And if we come to discuss matters of national interest, you don't need to discuss people who will not have the opportunity to rebut. It's not fair. And I thought that Mr. Okanse, you would have at least let him know that and stop it because it's not fair. The man is not here. So why do you make reference to him and describe him in very bad taste?
I don't think
it's not fair.
When he was going on that path.
But he did it about 4 times. He mentioned his name 4 times. It's not fair.
Reference. So I think you no. Mr. Jeff, hold on.
Akufo-Addo is different. He's a public.
Why we mention his
Hold
name?
on.
It's Godfrey Adame in the studio.
They are public servants.
But you don't know that. You don't know that he's a public servant. You don't know that Paul is a public servant.
Gentlemen.
You don't know he's the board chairman of the Ghana.
You are talking about him based on his media work.
Let's not
contradiction. Some of the people we are discussing.
You are talking about Paul. You are talking about Paul because his Metro TV programs. You are making reference to him as a media person. It's not fair. We are talking about Attorney General because he's a public servant. Akufo-Addo is a public servant. Paul Adumochire using Metro TV is not a public servant. And so if you are speaking to those matters,
who told you that journalists cannot be who told you that?
And the second point.
Where is he getting that from?
Let me say.
Sami Jemfi, you are not the person who holds the knowledge of the world.
Hold on.
You should know that. You can express your opinion, allow others to express their opinion.
Let me bring
those who are listening to us will judge what you are saying, what I'm saying. It is not for you to judge me.
Okay, let me say this. You are going to make your point. So
the second point is the second point is
allow the
second point is
so you go ahead.
Yeah, I have to make these terms before I go to my substantive point. Okay. The second point is he described Godfrey Adame as dishonorable. You see, when we are doing political discussion, we can disagree on matters. I may have my disagreement with Atoforsen, but I will not describe him as dishonorable. I will not do that. let's be responsible in the kinds of comments that we make. You can't say because of politics, you come and sit here and describe the Attorney General, who is your senior at bar, who is more experienced than you, who has achieved more in court than you. His achievement in law is more than you.
Hey, so he cannot be criticized.
He can be criticized, but the way should I call you dishonorable?
But don't go that far.
Yes, I have to go.
People do.
It's not right. We have to have qualitative discussion, focus on the issues, and not try to bring people down based on hatred.
Oh.
I mean, so should I say because I'm going to criticize Atuforsen, I should call him dishonorable MP? Is that right? What kind of politics is this? Now to now to the substance. I am outraged with the commentary by Sami Gyamfi, and I want to point out two matters in this case. Okay. The first one is the substance of the reason why the Attorney General is in court are the facts he has and has put before the court. That is what will determine whether Atuforsen is guilty or not. The issues of the third accused person raising matters of the Attorney General calling him whether true or false, I mean, let's say it's even true, are matters of his professional conduct that will have nothing to do with the case against Atuforsen. Let's separate the two. The facts before the court, even if it is established that the Attorney General called the third accused person to try to influence him to testify against the first accused person, that will go to affect the professional conduct of the Attorney General, but there is no way to affect the matter before the court. And I want to limit myself to the matters before the court. That is what is most important. If Godfrey Dame has misconducted himself, if they can establish that, I mean, the appropriate courtesans will deal with it. That has nothing to do with the matters involving Atuforsen. If there are professional matters that, the Attorney General has done, that they have evidence to prove, they should bring it. And if it is proven, he will be dealt with according to the appropriate agency. But, Okansi, this is a matter that the government of the NDC, from cabinet, they approved the purchase of 200 ambulances, as Sami Gyamfi stated. And it went to Parliament, and Parliament approved it. And Parliament approved for Stanbic Bank to establish LCs for payment of those ambulances. And in the contract agreement between government of Ghana and the company, the foreign company, which the third accused is the local rep, there are clear clauses as to what should happen. There are clear terms. And the terms are in the contract are that the suppliers should supply the ambulances. And there is a criteria, there is a desired ambulance that should be purchased. And on the basis of the supply, the contractor will be paid. Now, the Deputy Finance Minister goes to write for LCs for payment when the ambulances have not been supplied, contrary to the contract at the time. And two, the bank that was approved by Parliament to get the LCs for payment was Stanbic Bank. And in this case, they established new LCs contrary to parliamentary approval.
So, Honorable Chinia, to the extent that this matter is still...
These are facts. I am not drawing conclusions. These are facts.
I want to also draw...
These are facts the Attorney General has put before the court.
You make your point.
I know my limit. I know my limit.
That you should be minded that...
I know my limit, Okansi. I know my limit.
Be cited for
I am talking about facts. Okay. Facts the Attorney General has put before the court.
Because we haven't
I am not drawing conclusions.
We haven't gone into
Sami Gyamfi equally tried to give the facts of the matter. I mean, it doesn't have nothing. It does not have anything to do with if you go to draw a conclusion. I'm not drawing a conclusion as to what will happen. It is for the court. I'm only talking about the facts that Attorney General, which are public facts. Statement. that this is the contract. The contract is a public document.
Oh yes, let's
and in the contract
limitations. Yes.
Yes, in the contract there are terms of agreement. And I am saying that the terms of agreement, in the opinion of the Attorney General, were breached. Because the bank that established the LCs was supposed to establish LCs for payment as approved by Parliament. According to the Finance Ministry, they got expired and they didn't know, and they went to establish new LCs, which meant that logically they should have gone back to Parliament to get Parliament to, if those ones they approved were expired, they had to give the approval for new LCs to be established for payment. That is one. That was not done. Two, in the contract, the terms were such that the contractor had to supply before payment. In this case, the contractor did not supply, and the Deputy Finance Minister established LCs, and he was paid this amount. When eventually the ambulances that were brought,
so you see,
were containers. They were not actual ambulances, and that is established.
You see, I kept saying that.
Okay, so these are facts. These are facts. These are facts of the matter. It's not facts of the matter can be discussed. Facts of a matter in court can be discussed.
I keep bringing your fact. You say these are facts. These are the matters that are actually before the courts to be determined as fact or otherwise. But you are saying that you don't want to draw conclusions, and you are.
But these are the facts they put before the court. The Attorney General has put before the court.
But is that to say that...
Is the contract not a public document?
It is a public document. And
so can't we discuss the contract?
That this matter is actually before the court.
I am saying that the contract is a public document.
Be minded of the limitations.
And I'm talking about the terms of the contract, which in the opinion of the Attorney General were breached. I am trying to make the point that as for these, court proceedings that they are bringing, is for the NDC, is diversion of attention.
Okay.
The actual issues of breach of the contract and the evidence the former finance minister gave in court, he has read, I didn't bring, but the evidence he gave is contrary to the claim my brother is making. I mean, when he was cross-examined, he was not able to prove that he gave approval for the deputy finance minister to do that. He was cross-examined, and it was established. I mean, the former finance minister. The former finance minister.
You mean Setekwe?
Setekwe. And he himself could not point to any document that he gave approval for the deputy finance minister to do what he did. It's clearly established. So the NDC is only using the statement made by the third accused to divert people's attention from the real issue. And I'm saying that the real issue is what the Ghanaians should be interested in. As for the professional conduct of the AG, if it is established, it's a professional issue. It has nothing to do with the case involving the former deputy finance minister. And to add to my statement, look, the Attorney General has sued 3 people. The first accused, the second, and the third. And the third is the local rep of the contractor or the supplier. And he himself stands accused. And if the first accused is convicted, the likelihood of the second and the third also being what is convicted is possible. Because the second and the...
How do you draw this conclusion?
We are expressing our opinions.
No.
I'm saying the likelihood, if the first accused, because the second and the third accused are being accused based on the action of the first accused. So if the first accused is implicated by it, the likelihood of the second and the third also being affected is high. I am not saying it is an outright, possibility. But it is.
That's what I wanted you to, because your earlier statement is very different from what you are saying now.
No, this is what I mean.
Okay.
I am saying that if the first accused is convicted of the accusations, the likelihood of it trickling down to the second and the third is very high. Because the second and the third accused are being accused on the basis of the action of the first accused. So the AG is the one suing the 3 of them. So how do you sue 3 people? One of them has come to you with plea bargaining, trying to settle the matter out of court. And you know that his attempt is part of effort to free the first accused. The plea bargainings initiated by the supplier and his local rep is an attempt to get Atuforsen out of the case. So it means from day one, the fact that they came with plea bargaining in favor, is to favor Atuforsen. So I don't see how the Attorney General reasonably will think that the third accused is different from the first accused. Because the effort the third accused is making is to free the first accused. Because if you have the plea bargaining accepted by the Attorney General, it means that the chances that you have to spare all the three is increased.
Okay, so let me, Honorable Chinia, because you made a number of statements, I want to,
But he also made a number of statements.
Yes, I'm just telling you something. If you can kindly hold on. You said that Setekpe testified in court indicating that he did not at any point give authorization for this, the letter of approval for these ambulances.
You didn't hear what I said.
No, what did you say?
I said, in cross-examining him, he couldn't point to any document that shows that he gave approval for the Deputy Finance Minister to do what he did.
Okay, so let me tell you.
Because he was cross-examined.
So this was in October 2023. That is when Setekpe was in court. He told the Economic and Financial Court that he directed Dr. Kresla Atuforsen to write to the Bank of Ghana requesting for letters of credit to be set up in favor of Big C General Trading Limited of Dubai for the supply of 30 ambulances for Ghana. He was testifying as a star witness for the defense in the case brought against the minority leader. So I don't know where.
Oh, then it means what is it?
I just wanted to
you have to be fair to me.
Okay, what have I done?
Be fair to me.
What have I done?
This is a statement that he made when his lawyers took him through as a witness. But I'm saying that when the Attorney General was cross-examining him and put it to him to show any document that shows that he gave approval, get that statement too. He could not point to any document. And he said that, he actually said that the document they showed to him when Iuko met him was blurred. So he couldn't identify the document. So in the cross-examination, his testimony was different from what you are reading.
So,
I'll set the record straight. So don't worry.
You will. Let me also acknowledge the presence of Professor Apiejetua, who is a professor, associate professor of law at the University of Ghana School of Law, and then also, I understand the spokesperson for the Attorney General is also wanting to make an intervention. But
now number one, Alfred.
Let
me deal with a few issues. I beg you, a few issues. Number one, it is laughable that the Deputy Minister of Sanitation, who is a law student, will attempt to defend an Attorney General who could not defend himself in court. That's number one.
What exactly do you mean by that?
Number one. No, this is a Deputy Minister of Sanitation trying so hard to defend an Attorney General who, when confronted by an accused person testifying under oath, could not defend himself. You understand? When you should be focusing on how the rains have exposed how dirty Accra is, the floods and all that, he is interested in defending an Attorney General who could not defend himself. Number two, he makes this point, he goes into the substance of the matter, prejudicing the matter.
I have not.
Making pronouncements on the probative value of evidence. You see, he's a law student, so I'll pardon him. And I will not follow him there because I should know better as an officer of the court. But just to clarify that Setekpe was categorical through his testimony that he authorized Atuforsen. And if you check the ruling on the submission of no case, the judge has reduced the issue Atuforsen has to answer to that main issue as to whether or not he had authorization. This question he's talking about came up during cross-examination, whether he directed Atuforsen through a document. But tell me, common sense, tell me. He is a deputy minister. When your boss on a daily basis gives you direction on what to do in the office, does he always write it on paper? Are they saying that a minister must always write directives or assignments or delegation that he gives his deputy on paper.
In contracts and this
The most important thing, listen, the most important thing, as I've read to you from this record of proceedings, is that the letter Atoforsin wrote had the seal of the Ministry of Finance. Which seal is in the custody of the personal secretary of the Ministry of Finance. Without his approval, nobody can have that seal.
So
number two,
these matters are obviously playing.
So let's move. Number two, you see, he's cast aspersions of my person. Let me deal with a few issues. I'll do that quickly. There is no rule anywhere that if you are on a program like this and there is nobody in the studio, don't comment about that person. Atoforsin is not here. Alfred, you allow me on the floor.
Yes.
Atoforsin is not here. He has spoken about
different matter. It's a different. Don't compare the two.
Exactly.
Sami, don't compare the two.
Adomotre, look, when you were talking, you said I should not interject. I think you should give me that respect. You see, Paul Adomotre is a journalist who has commented on this matter. And therefore, we can comment about him. In his comments on this matter, he has spoken about me, and he has spoken about the number of people, so he can be spoken about.
You make a specific reference in response to the comment made, and not about
me.
the person.
Exactly.
I think
and in any case, that person is a public officer. He didn't even know. So this whole argument that somebody is not in the studio, so you cannot talk about him, is ridiculous.
You are not talking about his public office.
Number two, there is nothing wrong describing an attorney general who goes about influencing witnesses and accused persons unprofessionally under the cover of darkness to fabricate evidence.
That has not been proven.
My brother, you're going to allow me to talk.
It's an allegation.
You're going to allow me to talk, or else you will not have any time to talk.
It doesn't matter.
Yes. You're going to allow me to talk.
You say you are a lawyer.
No.
Respect
yourself. Respect yourself.
The man makes
Respect yourself. Respect yourself. Respect yourself. The allegation was not, it is not a mere allegation. It is evidence under oath. Which evidence the person against whom it was made could not dispute. And it is on the record. And I can talk about it. And say, I believe that because he could not dispute it. If you've been taught evidence, you will know the rules of evidence. Now, number two.
Is it number three?
Yes, number three. You see, aside the right to life, the most important right any human being has been given by God is your right to personal liberty. And so if somebody, knowing that you are innocent, seeks to procure false evidence against you, to deny you of your personal liberties, like Dame is trying to deny Atoforsin of his personal liberties, he's trying to get him jailed by getting an accused person to implicate him through false testimony. Anybody who does that is not only dishonorable, but he is a criminal. And we will say it over and over again. If Dame is a man, he should sue me. And I will adduce evidence to show that he is a criminal who engages in the fabrication of evidence against accused persons who are supposed to be presumed innocent until proven guilty. If he's a man, he should sue me. His spokesperson is on. Number four. Hold on, let me go on.
I have to respond.
So, like I waited for you to finish and respond. Wait for me to finish and you respond. Again, you see, I have read to you the ethics of the legal profession. Rule 13, Rule 40, Rule 54. I have read to you the provisions of the Criminal and Other Offences Act, Section 213 and 214. You've not been able to dispute any. So this circumlocution you are engaging, trying to defend the indefensible, trying to defend a man who had no defense when his accuser was before him, is neither here nor there. Finally, the plea bargain matter has been demolished, in the sense that plea bargain has never been initiated. They should educate themselves by reading Act 1079. Before plea bargain will even be initiated, after a proposal is made by a party, whether the prosecutor and the accused person, it must be accepted and the court notified that plea bargain has been commenced. It is upon the court being notified that an adjournment is given for the parties to go and engage in plea bargain negotiations. That has not happened in this case. The proposal for settlement was dated 27th April 2023. The revised proposal, May 2023. The AG objected and rejected all proposals in May 2023. The 30 days window has lapsed. So if only a few weeks ago he was in meetings with an accused person who is testifying in the court going through cross-examination, having secret meetings with him, impressing on him to skew his testimony in a way that implicates an innocent man at forcing. He's not only dishonorable, but he's criminally minded. He's a disgrace to the legal profession.
You are going to
no, first of all, we are starting with the press conference and the evidence. Martin Pebu wants the evidence. We will give you the evidence.
Okay.
And our honor is on the line. We will give you the evidence. And number two, at the right time, Godfrey Dame will be reported to the police. He will be picked up. He will be prosecuted. At the right time, he will be reported to the General Legal Counsel. I say at the right time because we know the kind of country we live in. If Dame can call an accused person to fix, a case with him, he can call a judge.
Let me not
to do the same thing. Hold on, let me land.
In 30 seconds.
He can do the same thing with a judge. He can do the same thing with a registrar. This only exposes his modus operandi. Okay? And that is why we are not surprised. No amount to obfuscate the issues and reduce it to NDC and people will wash. The accuser of Dame in this matter is Richard Jakpa. He didn't make his accusation on radio. He made it in court. Realize that he has not even issued a press release. Atoforsen has not issued a press release. Jakpa has not issued a press release to attack the AG. It is rather the AG who has issued a press release to make false allegations against them. If he is a man, he should meet Jakpa in the box and make those claims and let the Pandora's box be open. But whether the box is open or not, the NDC will open it latest by Wednesday. That press conference will be held and the evidence will be
wait for that press conference and what you're going to put out. Professor Appiah-Etuah, you will respond. Let me bring him. You will respond. Professor Appiah-Etuah is a professor of law at the University of Ghana School of Law. And a quick one, Professor Appiah-Etuah, first of all, let's establish this. Does the plea bargaining process, as established in law, include, for instance, the accused person being asked to help make a case against another accused person by the prosecution?
Well, based on what the third accused is saying, there seems to be something which is odd about the whole process because, like I said initially, it's not supposed to be imposed. It is that's why it's called a bargain. It's like going to the market to bargain for the price of a container of tomatoes or something. So it should be at the free will of either party. One cannot impose on the other. And so if it is the Attorney General that is suggesting for a plea bargain, it should come freely from the accused person to accept it. And then they negotiate the terms. There are different aspects of the free bargaining process. It could relate to the sentencing, it could relate to the charges, it could relate to the costs involved, it could relate to, for example, how much the accused person is ready to pay as compensation to the victim involved in the case, a number of factors. So all those things, the two parties will need to agree on. Sometimes, in most cases, involving their lawyers. And then they argue and they make a case that this is what I will lose. It's a kind of risk-taking as well. So you look at the advantage of going full trial and what you would lose or what you might lose if you go on a full trial. And then you go for a reduced trial, but you're losing something. And if you put everything in the bag together, you realize that at the end of the day, I'm better off not going full trial, even if I may lose some rights. And by looking at the bigger picture, I'm better off. You spend less time in the courtroom. You're able to save some time for some other activity. And so at the end of the day, you say, I'll go for it this way. So if it is being imposed, then it becomes a problem. It loses the idea of bargaining. And if you look at the Act, it doesn't accept that or recognize some imposition in this whole bargaining process.
You talk about imposition there, and that leads me to the specific quote attributed to Richard Jakpa, which has not been disputed, that the Attorney General on several occasions engaged him at odd hours to help him make a case against the first accused. This was not part of the plea bargaining. And as you have indicated, it is not part of the plea bargaining process. And it continues that if he pushes me, I will open the Pandora's box. I don't understand why the Attorney General will accuse me. It goes on and on. Now, that particular statement, which you have read and seen as well, does that raise any concerns for you from where you sit?
No, I don't think that is part of a plea bargaining process, because here you are trying to make the other person support the case of the other person. In a plea bargaining, yes, you can bargain that. Okay, here's a case where the main fish, if you like, in the case is one particular accused person, and if we're able to find him guilty, it will make our case stronger. As for the other parties, they are lesser or smaller fishes, if you like. Let me use that word. So the evidence that the other parties can give, you say that, okay, we will give you a lesser punishment if you testify against this person, or if you not provide some other reason or some other issues that if you don't present them, it will make the case stronger against another in any of the other parties involved as accused persons in the case. So, but this is not imposed. This is something that can be a bargaining chip that can be used to get a lesser sentence for the third party, or the other, in this case, the third party. But it is not something that should be imposed. Now, but looking at the whole scenario based on the facts of what we have heard, we don't know the details. But according to what is in the news, it is rather and I think even the Attorney General confirmed that it's the third party that initiated the plea bargain. If that is the case, then there is no way the Attorney General should take advantage of that to ask the third party to testify against the other party by way of imposition. Because if that is the case, and probably that is why the NDC, the third party in the case, made the court record it. Because if that happens to be the case, and then the plea bargaining is struck and judgment is given, but later on it is found out that the bargain was achieved through some arm twisting and so on, the court can nullify the whole process. So
I see.
It is not part of the plea bargaining process.
Right.
Trying to arm twist somebody, trying to push somebody to the wall is certainly not a bargaining process. It should be a free negotiating process, which at the end of the day should benefit.
It's a very instructive statement that you made in the end there, but where an accused person makes such allegations, Prof, against a prosecution during cross-examination in open court, and it is not contested by the prosecution, I mean, how will the court be required to treat a statement like this allegation?
Well, first of all, it is noted by the courts, and if it becomes necessary that it will affect the outcome of the case in any way, then evidence could be called to confirm or to ascertain the facts and to know what really happened. And if that is the case in this context with respect to the plea bargaining, the whole process, the whole plea bargaining thing can collapse, and normal due process will follow. And so that is what the court will do.
Thank you. Thank you very much for your input on this. Professor Appiagyei Atua is a professor of law, even an associate professor of law at the University of Ghana School of Law. They're also making very instructive statements in this regard. Thank you very much for this input. And I would come to you, Honorable Chinia, because Lawyer Martin People, that's that same question of how this allegation that is not contested would impact on the case going forward. there's been suggestions that either the Attorney General should recuse himself. Others say that, look, the veracity of this case, if so established, could lead to a mistrial. Is it one that can happen because of this statement, this allegation that was not contested in open court by the Attorney General?
Oh, yes. Yes, so the court has inherent jurisdiction, right, to stop the trial, okay, discontinue it, once the court finds that its processes, that's this prosecution, is being abused, is being used for a political vendetta. So meaning that if once it's established that the Attorney General had no basis for coming to court, but just initiated this particular prosecution in order to muscle Atuforsen, you see, in order to shut him down, then the court can stop the trial. Because you see, one thing that, especially if you add it to the fact that Big C had said, give us the ambulances, we will pay you back. So why are we in court? So if you look at it, once the tapes come out, it shows that the Attorney General was really suborning the witness. Oh, this case will have to be discontinued because we don't allow it. It's not allowed. You can't use the court processes for vengeance. You don't use it to muscle political opponents. No, that's what we call abuse of process. If we find that, that would be tantamount to abuse of process of the court, using it to witch hunt political opponents. That's not what the law is for. You see, and especially if you look at it, I'm tending to be on the side of Jakpa, though ultimately is the tapes that would resolve everything. Because, you see, in the past, there is an Attorney General who added ACP Dr. Benjamin Agbojo to the treason trial when he himself had no basis. And he told me, and Agbojo was standing there, that, oh, we just added him. Just added him so that the case will look credible. And destroyed an assistant commissioner.
He said that to you?
Yes. Agbojo was standing there. That's my luck. So it's not like I had to go in. He was standing behind me when Dami said it. Move, you come to Cecilia Dapa on Saturday, 4th May.
For malicious prosecution?
We are looking at that. Okay. On Saturday, 4th May, what did Dami do? He went on Joy FM and lied about Cecilia Dapa's case, said that Mamiti Wadodankwa had conducted thorough investigations and found nothing. Meanwhile, your own letter that you instructed Evel Kilson to write, you said Yoko was here to commence investigations. So if you add this attempt to free Cecilia Dapa, what he did to ACP Dr. Benjamin Agbojo, okay, I'm tending to go with Jakpa, though I will hold my horses and wait for the tapes. But Dami, no. Dami has
okay. So you will come to that later. Okay. Now, I think that because you are also a student of law, I keep coming back to that. We cannot wish away the impact and the extent. No.
Part 1 or 2?
It's part 1. Part 1. Yes, it's part 1.
This one after the program.
It's part 1. No, let's.
I'm not a lawyer. That is the most important thing.
He's in that.
But you're studying law.
He's studying law. Part 1. Yes. That it should be of concern, is it not? I mean, regardless of where you sit, that because it could happen to anybody.
Yes.
That if a statement like this is made, which is not contested in court, how do we treat this?
You know, in my submission, I don't know whether you paid attention to what I said.
I did.
I said the issue the third accused person made in court is about the professional conduct of Godfrey Dami. For me...
Is it just about the professional conduct?
If it is established that he tried to influence him, it's about his professional conduct. It doesn't go into the merits of the substantive case in court, where my interest is. And for me, the substantive matter is about the contract that government of Ghana signed with the supplier and how the terms in the contract were applied. That is what is before court. In the case of the third accused person making an allegation against the Attorney General, is yet to be proven. The Attorney General has also made an allegation against Atuforsen. It's yet to be proven. Let's wait for both to prove their cases or their allegations.
But to the extent that the Attorney General was in open court and did not contest it.
Well, I mean, lawyers will conduct their businesses the way they appreciate it will serve them better. If he thinks what the man said has no material evidence against him, and you know, when somebody makes an allegation, the burden of proof is on the person. So the third accused person who made the allegation against the AG is the one who must prove that what he said is true. It's not the AG who come and prove that it's not true.
This was captured in the
it doesn't matter. But the establishment of the facts, whether he actually did that or not, is on the third accused to prove.
Okay.
Now, I am concentrating on the matter which I believe the NDC and Sami Gyamfi and co are trying to divert Ghanaians' attention from. And that is the contract that government of Ghana entered with the supplier. What are the terms in the contract? Because if you have a good case and you put before court, you don't need to coerce somebody to come and support you. And for me, from where I sit as a student of law, I think the Attorney General has a strong case before court that he doesn't need the support of the third accused person to prove his case.
Okay.
Because the contract is there, the terms are there, and if the terms are violated, they are put before the court, and you can pinpoint to the violations, which I believe the Attorney General has done. You see, we don't need to get into the matter. Otherwise, the bridges are there. It's clear. You sign a contract with somebody, the person is supposed to supply ambulances to a particular specification before he's paid. Before he's paid. He didn't supply the things, and you paid him. And when you even supply some, they were not up to the specifications. It means you breached the contract.
But today they are saying that we should bring the ambulances for our money.
I think that
but why did they even supply that in the first place? Why did they put in it? Are they ambulances?
Yes.
I haven't finished. No, we can't.
Gentlemen, hold on.
I haven't finished.
Conclude on your point.
You see, Sami keeps insinuating and using bad language against the Attorney General. It's not every accusation that you make that will turn out to be true in the court. He himself made an allegation against the energy minister. What happened? Was he able to prove it in court? He couldn't prove it. You made an allegation against the energy minister. So the fact that the third accused person has made an allegation against the Attorney General, I thought that we would have waited and brought the evidence. You shouldn't be speaking plenty. Why do you speak? You are a lawyer. And lawyers, I mean, you have your evidence. Bring the evidence and show to Ghanaians that this is what the Attorney General did. Why are you ranting and insulting the man and saying all kinds of things when you yourself have made several allegations against people that you couldn't prove, and you have been fined in court because of lies?
All right. Well,
we should stop this.
So you made your point, and I'm concluding on this. Yes.
Response. Number one, there's not been any trading of allegations. What Jakpa said was testimony under oath. It is evidence he gave in court, part of the court record. It is not an allegation. It is the Attorney General who, as a coward, could not dispute that, came into the media to make allegations. You see, when you are talking, I'm quiet. When you were talking, I was quiet. Allow me. Respect yourself. Number two, he's gone on and on and on.
The fact that the man made the
Masa, can I make my point?
Hold on.
If the man made an allegation in court, you are telling us that is a fact.
You don't even have the capacity to even argue with me on issues of evidence. So keep quiet and let's talk. Keep quiet and let's talk.
Gentlemen.
When you were talking, I was quiet.
What capacity do you have?
Number two.
What capacity do you have?
Hold on.
What capacity?
Let's stay focused. Let's stay focused.
Conclude.
Number two. He keeps on saying that they have a good case. They have a strong case. The Attorney General has already established that. And yet this is the Attorney General who is going about coercing witnesses to bear false testimony so that he can jail an innocent man. If he had this good, wonderful case you're talking about, why is he doing that? It is all the things he has said about the terms of contract we signed are false. Palpable falsehood.
Okay.
The contract was signed in November 2012. Letters of credit issued by the Bank of Ghana as security, which had condition precedence, which condition precedence says that the ambulance have to be shipped and payment can only be made on site. In October 2016, 10 of the ambulances were shipped with medical supplies. This government came, refused to clear the consignment when they know that the Ministry of Health is the consignee and only they can clear it. They've allowed thieves to vandalize the vehicles. They've allowed the medical supplies to be stolen. Some, as I speak to you, the imported medical supplies have been at the port for 8 years. They who through their negligence, this is just like Saglimi. They through their criminal negligence
all of
have
this
occasioned a financial loss to us, have the effrontery to sit on TV and accuse people of financial loss. I deliberately didn't want to go into that because the matters are sub judice. But I want to sit here. I won't sit here as an officer of the court and allow a student of law lie about proceedings in court. It has never been established anywhere that there was any problem with the terms of the agreement. Okay. And finally, Alfred, let me make this point.
All this you said have been stated in court.
In court.
At every
Go
point.
And look at the testimony of the 10 accused. He said that because we brought the first 10 ambulances, and they allowed thieves to steal, vandalize, steal the equipment and all that. We then decided that we will bring the vehicles, bring the supplies, do the installation in Ghana, train your ambulance operators and hand over to you. You have refused to clear the medical supplies at the port for 8 years. Having occasioned this financial loss, you are accusing, pointing fingers at others. Let me conclude on the personal attack on my person that I made an allegation about the Minister of Energy who I couldn't prove. As a student of law, he must know that the High Court is not the only court in Ghana. That matter is pending in a higher court, the Court of Appeal. There is an element of it pending in the Supreme Court. It is after the matter has come to its end, all the way to the review panel of the Supreme Court, or if I give up at a certain level, that you can say I've not been able to prove. In any case, who doesn't know? Seydou Imba himself is on tape.
So
the tape. Let me conclude. Hold on, let me conclude. Seydou Imba, Seydou MBA, is on video speaking to how Napo, the energy minister, recruited him, got him juju, got him rings, and has used him for violence. The tape is there.
But the court has ruled against you. So you are saying that this matter is in court.
That evidence was not.
So you believe that this case is in court.
The matter was.
The court ruled against you and you have been fined.
The High Court. Now we are in the Court of Appeal.
Continue.
There will be an application to adduce fresh evidence.
This matter is in court.
We are now starting. This is not.
Thank you. Thank you. Thank you, gentlemen. Thank you. Thank you. This matter is in court. Thank you. The 31st of this month, this case will be called in court, and we will be there to obviously report it. So let's wait until this matter. So wait, gentlemen. No. We'll be back shortly after this quick break. We'll be back after this quick break. We'll be back after this quick break. Stay with us. We'll be back shortly.